Good morning and good afternoon, everybody, and welcome to the D&O Exclusions You Need to Be Concerned About webinar. I'm Marketing Manager Sherry Branson. I'm now joined by Kevin Davis, the founder of Kevin Davis Insurance, and Kevin joins me now from Los Angeles. Hi, Kevin. Good morning.
Hey, good morning, Sherry. How you doing?
Doing great. Doing great. And Kevin, I hope you're staying safe. I know wearing your mask, and I'm wearing my mask
every day. Yep. You're wearing yours too, right?
Yes. Just not, I didn't put it on for the webinar, but I've been wearing it, everywhere I go. And yeah, and I hope everybody, we have several hundred people joining us today from all over the country, which is our usual crowd. And we'd like to welcome everybody from the East Coast to the West Coast to the North and the South. And Kevin, we have a great webinar today. We have a really, really great webinar.
I'm telling you what, I'm looking forward to this webinar because it is really, it's so much misinformation out there right now about what's covered, what's not covered. Is the D&O picks up all these different things. And today we're going to talk about the exclusions in the D&O policy. What is exclusions that are important? What do you need to know? You need to understand that the D&O policy is really, really unique. And we're going to find out what kind of exclusions out there will get you in kind of trouble.
Absolutely. Yeah, there's a lot of uncertainty in the world, so this is a very timely topic. And I did want to mention that I record all of the webinars, and I put the recordings on our website, which is kdisonline.com. And if you have any questions during today's webinar, you'll see a questions box on the right side of your screen. Just type your questions into that box, and at the end of today's session, we'll answer your questions. And if we don't have time, don't worry, to get to your question, we'll call you or email you later. So feel free to type your questions in there as we're going along. And Kevin, so we're going to talk about different exclusions today found in a D&O policy. What are the most important things that people should be aware of?
Okay, first of all, there are different types of D&O policies out there. Okay, most of the D&O for condominiums are in the package policy. I would say 80% of every condo homeowner association out there are in the package policy, either in their their CAU package or their travelers package or their farmers package or the state farm package. They all like, so there's different types of D&O. The key thing to understand is that D&O for community associations are unique. They're different. When you have a D&O claim for a community association, it's usually about something other than money. So we have to be careful when you buy a D&O policy.
Absolutely. Yeah, buyer beware. Make sure you know what's in the policy when you're buying it. Like you said, there's package policies, standalone policies, and let's talk about D&O liability. Let's get to the basics, the nuts and bolts of D&O liability. Can you talk a little bit about what it protects an association for? Okay, I think Kevin is frozen. Yes, I think he is frozen. So I'll keep going ahead with what we're going to talk about. D&O liability protects the insured against a claim for a wrongful act made against them during the policy period. So basically, a package policy insuring agreement, we will pay the sums which you become legally obligated to pay as damages because of a claim for any wrongful act committed by an insured. So basically, package policies are different than D&O standalone policies in the sense that you get more coverage with a standalone.
Okay, I'm back.
Okay, great, Kevin. Yeah. I'm sorry, we combined this in two slides not to confuse people. A package policy doesn't cover as much as a standalone policy. So yeah, I was just talking about that a little bit.
All right, and the key is this, is that when you talk about the D&O policy in the package, it's geared to legally obligated to pay as damages, okay? Versus the D&O policy for community association, which is insured for a claim for a wrongful act, has nothing to do with damages at all. That is there's nothing more important than that in terms of the D&O. The D&O policy is a broad contract. There are three pieces involved in it. It protects the insured, who is every volunteer, committee member, board of directors, so everybody who's involved in a community association. Number one, that's who the insured is. A claim is a written demand for monetary and non-monetary losses, both monetary and non-monetary losses. So that means claim for everything. A claim for I want money or I don't want money. So it's covered. And a wrongful act is any act, error, omission, misstatement. So any act. So if you have an insured who's everybody, a claim, which is anything, and a wrongful act is pretty specific. So it's really broad contract as opposed to a package policy where there have to be damages involved. So that's number one, the most important thing. So that's why the exclusions under a policy, it's critical. That's why the exclusions are really important in terms of what's covered and what's not covered. So talk about our exclusions here.
Okay.
Okay, when we talk about exclusions, let's talk about why we have exclusions. Okay, when we talk about why we have exclusions, there are 4 reasons to have exclusion under the D&O policy. The first one is eliminate coverage for uninsurable losses. So certain things are just uninsurable. You can't buy insurance for it. Second one is to eliminate duplicate coverages. So coverages that's already provided in other policies. The third one is to eliminate coverage due to conduct, meaning that's willful and wanted. You did it, you know you were doing it, and you want insurance to pick it up.
Mm-hmm.
Fourth one is why exclusions, to keep premiums reasonable. So the lower the rate is, the more exclusions you're going to find in a D&O contract.
Absolutely. So if you find one that's very inexpensive, you have to look at why is it so inexpensive? What does it exclude? And it probably does not cover much. So that's a good thing to keep in mind. Mm-hmm.
And that's the main thing we've been talking about, is that I think a lot of times people ask why the rates are so high on a D&O policy. And the higher the rates, the more coverage you're going to have. And you'll learn that over time that you see a D&O claim, they usually fall in several different categories. But right now, it is the one we're most particular about is the exclusions. Why exclusions are in the policy. So let's start with the uninsurable loss exposures.
Okay.
All right, Sherry. Now, when we talk about the uninsurable losses out there, they kind of fall into several different categories. The first one is people talk about this pending and prior litigation. Nobody's going to buy a new D&O policy, contract, and there's litigation out there already and provide coverage for that litigation that's already in effect. Mm-hmm. So D&O policy, that first thing is that prior and pending litigation part of the policy.
Mm-hmm.
The first.
Okay, that's very important.
The second one is any known fact, circumstance, or event in the event of a claim. So it provides prior acts coverage as long as you don't have any knowledge of prior acts.
Okay.
All right. The next one is nuclear, which you're not picking up anyway. Nobody's going to pick up nuclear. And the fourth one's interesting is construction defects. Nobody's picking up construction defects. It's uninsurable because if you have a construction defect loss, it's going to be in the millions and millions, tens of millions of dollars. So these are several of uninsurable loss exposures. So if you get declination on these things, it's because they're not insurable.
Okay. What comes to mind, just an example that comes to mind in construction defects is there's an apartment building in San Francisco that had constructed. I don't know if you've heard about that one, but it's kind of crooked.
Everybody has.
Yeah, that's unbelievable. The people, last I saw, the people were still living in it, even though the floors were crooked. And yeah.
It's right on Market Street, the high-rise condominium Market Street. And it is tilting and sinking and everything, and it's been a problem for a number of years. So
yeah,
reason why you can't find construction defect insurance.
Yeah, like the Leaning Tower of San Francisco. Yeah. Great. Okay, so those are areas that are just uninsurable. Nobody's going to cover those. And again, if you guys have any questions about what we're going over today, feel free to type your questions into the questions box. And Kevin just sent in a question that they wanted me to mention our website again, where you can listen to the recordings. The website where all of our recording is for today's webinar and all of our past webinars is kdisonline.com. That's kdisonline.com. Visit that website and you can listen to all of our webinars.
All right, good. Okay, so now let's talk about the addressed by other insurance policies.
Okay.
These are the exclusions that we run into more and more and more. Number one, bodily injury and property damage. Whenever there's a D&O declination, this is the number one reason why it's declined. Because people believe that just because you breach your fiduciary duty, that it covers everything, and it doesn't. Bodily injury and property damage is a general liability exposure, not a D&O exposure. So even the board is sued because they fail to maintain the common areas, or they fail to fix the roof. If it's any way based upon attributable to bodily injury, property damage, the D&O coverage will not pick it up.
Okay.
Okay.
That makes sense.
Another area is pollution. We won't cover pollution. And pollution is kind of tricky because in certain situations, if you look at the definition of pollutant, sometimes the word noise is in there. So watch out, because you end up seeing once in a while that noise pollution is excluded under the D&O policy. And again, if you live in a condominium, I know you live in a condominium, don't you, Sherry?
No, home, HOA.
That's right. You live in an HOA, and sometimes you go out there, and that pool could be pretty noisy, can't it?
Oh yeah, very loud.
Yeah, and so and sometimes it can get loud at late, and sometimes get loud, and so having that noise pollution exclusion in there is kind of it's watch out. So and then dishonesty is also excluded under the D&O policy because it's covered under the crime policy.
Absolutely. I did want to mention the pollution and the noise pollution too. I've seen claims with even hardwood floors in condominiums where people will take up the carpeting and put down beautiful hardwood floors, which are expensive, but then the people down below say it's very loud. So there's like really unusual areas that you can see claims in that you wouldn't think of. You wouldn't think of floors causing a noise claim, but it could.
Yeah, and it's really interesting because it's the job of the community association to make sure that you enjoy the peace and quietness of your surroundings. And right now, it is really one of those issues that we're going to see a lot of, because if there's noise, that means there's gatherings. There's gatherings, that means people are together, and people start to panic because they want the board to do something about it. And that's one of those that, again, is going to be a problem for the community associations in the future.
Absolutely, and more people are working at home now too, so that there are more people at home than there used to be. And
I would say too, in terms of the noise part, and in terms of all these different things we're going to be talking about that we're going to see in the future, the job of the board of directors have changed, where they, instead of enforcing the rules, now they're going to have to be able to be more proactive. That while people who live there want to be more proactive so they can stay safe. And so the exposure has increased tremendously for community associations. That's why today talking about these exclusions is so important. The less exclusion you have on a D&O policy, the better the D&O contract comes into play. So when you get that claim that comes in and said, guess what happened to me, you want to make sure it's covered.
Absolutely. Yeah, the board members have much more responsibility than they used to have. I think it's just getting more and more amplified by the situation that's going on right now.
Yeah, sure. So we talked about uninsurable loss exposures. We talked about addressed by other insurance. Now we talk about conduct exclusions. These are exclusions that are willful and dishonesty and fraud, willful violation, gaining any profit or advantage not entitled to. And that was an interesting one, because when we talk about gaining a profit or advantage, you have boards of directors who will decide to take a vacation together or to use the budget to buy themselves something they shouldn't be buying themselves, a big party, a big dinner. They're not entitled to. Gaining a profit or advantage they're not entitled to is an exclusion, because you're not supposed to do that. For salaries, commissions, compensations, and bonuses, all those things that are conduct. And an interesting one, the one is discrimination. It's illegal to discriminate. So, including American Disability Act and Fair Housing Act. But some of the policies do provide defense costs. So you're going to make sure at the minimum there's defense costs under some conduct exclusion. Some there's no coverage at all, because it is against, you can't do it. You can't insure things that are willful. Conduct exclusions are really, really important there. So can't insure. So
okay, great. And now, Kevin, I know we talked a little bit earlier about, keeping the premium low, and how that's, the main goal of adding a lot of exclusions to a policy. The common sense would say it keeps the premium low. So let's talk about like a lot of common exclusions that you see that a lot of carriers use to keep the premiums inexpensive.
Well, and this is probably the most important part, because these are where your exclusions come into play, where people say why your premiums are so high, and this is the reason why. The number one, the non-money damage exclusion. If you have a D&O policy that pays damages only, or as a result of damages, most of our D&O claims we're going to see is not because of damages, because I believe Sherry, as the president of our homeowner association, doesn't have the authority or the approval to tell me I can't go to my pool at this point in time. Because right now, there's no bigger concern out there than me going to my pool. I want to go to my pool. You can't stop me from going to my pool. I don't care what the governor said, what the mayor said. We're not a private company. We're private. We're a nonprofit. We're not a government entity. I want to be at that pool. So you, Sherry, have to allow me at that pool. Now, I'm suing the board, okay, to find out do I have the right to go swimming or not. I want a judge to tell me I can't go swimming, not you as a board president. That claim is excluded under most D&O policies that are found in the package.
That's a big one.
It's the biggest one. It's the biggest exclusion you have out there today, because if there's a D&O claim that we're going to see more and more of, is people who live in these condominium associations and want more freedom than they're allowed to have because of COVID-19. Okay, and the board of directors is to limit the freedom for their own protection.
Of course, yes. And right now, many pools are closed down. A lot of associations haven't even reopened their pools yet. So this is a very real situation that I'm sure is going to happen, or that's happened already.
Yeah, and I would say right now, our number one claim that we're seeing is who are you to tell me I cannot go into the pool?
Right.
We are not a government entity. So if you see in your policy that will pay only for damages, right now, that number one claim that we're going to see in the future is not covered.
Wow. Yeah, that's scary. That's scary. Okay. So this is really important to make sure that you have this coverage. The
second one, the noise exclusion we talked about already. Discrimination, again, we kind of talked about it. You want defense costs for discrimination, because again, what could happen is that not only they're saying that the reason why you're not allowing me to be in the pool, I have a disability. I need to go swimming every single day, every hour on the hour, and because you're not doing that now, you're discriminating me based on my disability I have.
Right. Yeah. I mean, there's really, I mean, there could be a million reasons why people could say, I have the right to do this. And if you're telling them they can't do it, they're going to get upset. It's just human nature.
And again, that discrimination part, you add to it, all of a sudden now you're talking about lots and lots of money, because now you got to prove that you didn't discriminate against them. And if you let one person in the pool because their disability, you got to let other people in the pool also, because they'll come back and say, the reason why, because of my race or because of my gender. It really creates a problem. So again, sure that discrimination's in there is really, really important.
Absolutely.
Okay. The next one, employment practices. It's important to have employment practice if you have employees. If there's employees, you're going to see problems from them. These condominium associations, they don't have HR departments. They don't. Okay. So when you terminate them, you don't do it the right way, you're going to see a significant claim under the D&O.
Right. They're making decisions every day that, if you're a human resources professional, you understand what you can and can't do. But a board member might not have an HR background, or they may not have consulted with their attorney, and then they make a decision, and that could be a very expensive claim.
It can be. Insurance insured is the most interesting one of all, because when you buy a liability policy, all liabilities say you can't sue yourself. You can't sue yourself. So, but in community associations, it happens all the time. If I'm the president of the association, Sherry, you were the president 3 years ago. Again, I'm making a decision right now to close the pool, close the gyms, close everything. I close the front gate. Nobody can come in here unless they are, let's say tested first. Unless they give them a thermometer, do the whole works. I shut the whole place down. Okay. Now, you were the president 3 years ago. Okay. And now all of a sudden, you would hold me responsible, because now you can't get your children in, you can't get your parents in, you can't get your dog in. Nothing gets in. So now you're going to hold me responsible, because you're challenging me on my authority to be able to shut down everything.
Right. And people will do that. People will say, well, who are you to say that we can't do X, Y, and Z? Or we can't have visitors, that kind of a thing.
And the first thing that happened to you as the past president, you're going to say, when I was president, we were open and we were honest with each other. We had pure openness to everybody, and we never would do anything like that when our term was president. You, as the past president, are looking at the new situation and you think that they are very dictatorial, they don't have the authority, and you're challenging them on the authority.
Yeah, so previous board members can sue current board members, and it can go back and forth.
Same thing. You're the current board member, you're the current treasurer, I'm the current president, and we disagree on, budgeting. I think we now should budget to repair the south-facing fences and the decks. Right? You disagree. You think that the reason why I'm going to do it because my place comes self-dealing. Now we sue each other, and again, it creates a major, major problem. Insurance is probably one of the big areas that we were surprised that we cover as much as we do. We see as many claims in that area. But again, if you live in a small association, eventually everybody's going to be a board member or a volunteer or a committee member. So everybody's going to be insured eventually. And so,
that's just, and I did want to mention to everybody joining us today, we do have claims examples that we can send you. So if you'd like some claims examples, let me know. And I do have marketing flyers on all of our products on our website on kdisonline.com.
All right, the next one we have a breach of contract. A breach of contract is an exclusion that's in most policies because it's really what is interesting, because if you decide to breach the contract, if you hire a painter and you say, listen, paint the entire complex, and all of a sudden you look and say, wait a minute, the color you painted it was not the blue I'm looking for. I was looking for a nice blue. It's a bit lighter, so I'm not going to pay for it.
Okay. So you just decide to fire that painter. You're just firing the painter, saying, okay, we didn't like the color, we didn't like your work, we're going to change companies.
That's it. The problem with that is that now all of a sudden you're going to sue the board because they received the benefit already. It's been painted. Now you don't like it, you choose to pay it. So those things are usually in the uninsurable situations. You really don't want to insure, because again, if you insure that kind of things, then boards of directors all over can say, I'm not going to pay it, sue me, the insurance company going to pay for it. But what happened with breach of contract is that sometimes it's not intentional. And sometimes they believe they're doing in the best interest of their community association. They're going to pay a contract because you didn't live up to what you said you were going to do. So what a lot of D&O policy will do is provide a defense for breach of contract.
Okay. And like you said, associations are signing contracts every day with painters, with landscapers, with all kinds of vendors, nonstop. And they're deciding, okay, we don't like this week, we want to change companies, and they may not consult with their legal counsel and decide to end the contract, and then it could be a problem.
Yeah, and it happens probably more frequently with property management companies. They enter into a contract with a property management company for 12 months. Then it's automatically renewed for 12 months later. And this automatic renewed is automatic renewed. Well, you get a new board of directors come in and they're saying, guess what? We don't like the management company. We don't like the job they've done. We don't think they're cleaning up properly. We don't think they're doing the budget right. We don't think they're doing the thing. And I have a better one that I know. He's related to me and he's great. So now all of a sudden you have a situation where contract's canceled, you have a breach of contract claim.
Absolutely. Yeah, very common, very common. I've seen a lot of those.
Let's go to the next one. Failure to maintain Procure insurance. This is an interesting one. Again, this is one of the ones that I worry about today in terms of this COVID thing. Will we see situations where the board of directors are sued because they failed to have COVID-19 protections available? Now there is none available, but would that be a lawsuit against the board of directors? Answer is we don't know. Right now, the failure to maintain or procure insurance is one of the exclusions that historically has always been in the D&O policy. But again, it should not be there anymore. It should be gone. So that if there's a D&O suit, because the board failed to have proper insurance, there may be coverage. Now, the tricky part of this is, again, it goes back to the bodily injury and property damage exclusion we talked about earlier. Okay. Because of the bodily injury and property damage, if you sue because of anything had to do with COVID-19 or any other situation, If it's because of bodily injury, there's no coverage.
Mm-hmm.
Okay? You say somebody is sick, that somebody's dying, there's illness, any of those things involved, there's no coverage. So when we talk about failure to maintain or procure insurance, it cannot result in bodily injury at all.
Okay.
Am I making sense?
Yes, yes, absolutely. Yes.
Okay.
Mhm.
So
Yeah.
that's a tricky one because, again, most people think that just because there's no failure to maintain insurance, that they can sue because there's a major flood or there's an earthquake. And all of a sudden, guess what? You don't have a failure to maintain insurance exclusion in the policy. We should get coverage. No, you don't, because the property damage supersedes it. But for the property damage, but for the bodily injury, there would not be a claim. That's why that's there.
Mm-hmm. Mm-hmm. That makes sense.
Yeah. Okay.
Mm-hmm.
The next one is failure to render professional services. That's for your management company. If you see that on it, that means your property management company is not being covered. Under the D&O, you have to make sure your property manager is an additional insured. They must be an additional insured. Okay. A lot of times they say they are additional insured under the GL policy, but not under the D&O policy, because they'll have exclusion rendering professional services. So now the board invites the property manager in. Property manager says, here's your budget for the upcoming year. The budget is, they don't like it, and they sue the board and the property manager because they didn't budget properly. Or better yet, what happens more than any other time is they tow the car away. The property manager tows the car away because it's been parked in visitors parking for the past, every night. And all of a sudden the property manager gets sued along with the board of directors because you didn't have the right to tow my car away. Those are rendering professional services that may be excluded under the D&O policy if they have that in there.
Yeah, it's very important to have the property manager covered because they're making so many decisions on behalf of the association. They have such a huge responsibility. So make sure that the policy has property management coverage as an additional insured.
Yeah. And finally, you have personal injury and publisher's liability. That's covered under most general liability policies. What we have found is that sometimes we're excess of the personal injury publisher liability, but sometimes when the market is really, really tough, you find exclusions of personal injury and publisher liability in the policy itself. So therefore, guess what? No coverage.
No coverage.
It's important to have that in there for excess purposes, or just in case you happen to have a general liability policy that's limited and excludes those in there, and then you have it. So I'm exhausted.
That was a lot of talking, Kevin. We covered a lot of good information, a lot of good grounds, and we got a lot of questions that have come in. So
let's go to questions.
Thank you, everybody, for sending in your great questions. And let's see. Okay, Craig, we have a question from Craig. Thank you, Craig, for asking the question. He'd like to know if the board opens the pool, we were just talking about the pool, and someone gets sick and they file a D&O claim for the board's decision, will the traveler's policy defend?
Okay, that's the number one question we've been getting day in and day out. Okay, once you said if they get sick, that voids their coverage. If they sue because I want to be in the pool, again, it's a standard breach of fiduciary duty claim. Guess what? I want to use the pool. I have a disability. You board of directors don't have the authority to do it. Okay, that's where coverage may apply. It really depends on the way it's brought out. But once you mention somebody got sick, somebody may get sick, somebody has been sick, somebody may get sick in the future, that's it, automatically. But for the property damage or bodily injury, that's what you can do. If that resulted in bodily injury, there's no coverage.
Okay, thank you. Michelle, thank you for the question, Michelle. She'd like to know never mind. She asked about the website. I'll give you the website one more time, kdisonline.com. You can listen to all of our past webinars and today's webinar. So feel free to visit our website. And we also have product videos there as well. Okay, Brandon would like to know, does the age-old adage, if it is not excluded, it is therefore included, apply?
Okay, again, that's an
interesting question. That's a good one, Brandon. I like that.
And that's why the exclusion and D&O is so important. Again, if you're an insured, which is most people in the association who participate, who can be sued, and it's a claim, either money or non-money, a written demand. It's just a written demand. Somebody in writing saying, stop doing what you're doing or else, I will sue, or just stop doing this written demand for a wrongful act. And a wrongful act is any act, error, misstatements, or omission. It's a long thing, but basically it says any act. So basically, it's pretty much a all risk policy except for what's excluded in the policy, but also other terms and conditions too. For example, the biggest one right now we see is late reporting of a claim. Okay, so if you get a declination, because you do get a written demand, you get a written demand saying that I don't like what you've done. Please open the pool immediately or else. And then you're a board member and you say, this guy is yelling, screaming again. 6 months later, a year later, a lawsuit comes into play. Guess what happens? Now all of a sudden you have a late reporting situation. Because it goes back to the pending and prior exclusion we talked about, the known prior acts thing. So be careful on those situations, because again, you can be in a situation where it's just more than just the exclusion of the policy. It is just one of the conditions of the policy to make sure you report a claim as soon as possible.
Report it immediately. Don't sit on it. Don't wait. You definitely don't want late reporting, which is a big problem.
It's probably the second reason why we get declined. Number one is because it's covered under someplace else, okay? But another one is because of late reporting of a claim.
Absolutely. Great. And we have another question. Thank you, Tina. Tina sent in this question. As far as prior knowledge, we have lots of boards who say to us, we have issues pop up all the time. If we notified you every time there is an issue with an owner, we'd be notifying you every day. Interesting. When do we really know when it's appropriate to notify the carrier?
Okay.
Excellent question, Tina. Excellent.
Tina, it's basically when you get a written demand, when it's in writing. When it's in writing, you got to let us know. You let everybody know when it's in writing. Yes, every board of directors and every condo out there gets yelled at every single day because of certain things that happen. You have to let us know once they say, here's something in writing, please do something about you. I demand you open the pool up immediately or else. It's a written demand. Put us on notice, because you never know what happens 6 months from now or a year from now when they come back and sue you because you didn't open the pool. I could not sell my unit in my condo for the past year, and I'm going to sue you for money.
Okay. This ties into the next question. Jessica wants to know basically what you just discussed. Due to the COVID-19, many associations have decided not to reopen many of their amenities, pools, etc. So she wants to know what you just talked about. If a resident sues the board for not reopening, for keeping it closed, will the board be covered?
Okay. Again, it's going to depend on exactly what the suit is in there. If they say, I'm afraid of people getting sick, again, the perfect example I used before, because of the pools closed, my unit has diminished in value. So instead of my home being worth $250,000, now worth $200,000. I'm suing you, board of directors, because now the value of my unit diminished. I'm not suing for any bodily injury or property damage. I'm suing you because of a breach of fiduciary duty, because I lost money in my unit, And that's a lot different than saying, I want the pool reopened immediately because I want to go swimming and you don't have the right to do it and people are going to get sick and things like that. Once you start putting in things of illness, death, COVID-19 itself, use that word in it, I would say you're in trouble.
Absolutely. And speaking of that, Kevin, Barbara, thank you, Barbara, for your question. She wants you to go, what you just talked about, going back to the prior question as well about, she says, I'm sorry, if you can please reiterate why the claim for stopping unit owners from going into the pool will be excluded. Just talk about that. Again, yeah.
Right. Okay, so now the boards of directors, okay, again, it's too simple to say stopping. Why they're being stopped from going in the pool. The question is why they're being stopped. If they're being stopped has anything to do with bodily injury, then that's the reason why. And now if they stop because, okay, here's a perfect example. I have you live in a homeowner association. All of a sudden, your pool hours from 10 o'clock in the day to 10 o'clock at night. So now it's 2 o'clock in the morning, you want to go to the pool. I stop you from getting into the pool. because I'm the president. Now you sue me because you believe the 10 o'clock is unreasonable, right? It's unreasonable. It's a reasonable decision you made. That's a D&O. So if you're saying right now that I should be in the pool, board of directors made a decision that's unreasonable, it's just unreasonable. That right now, I want a judge to determine the reasonableness of the decision you made. It's a lot different ball game than you saying the reason why because people are sick in the pool or people may get sick. Those two different ways of looking at it.
Okay. And okay, great. And Michael M would like to know, is there a way to provide coverage outside of the insured versus insured exclusion?
Oh, again, there should not be this. Again, when you look at these exclusions, keep premium low. These are the exclusions in there to have lower premiums. So if you buy a policy, D&O policy, that costs a little bit of money and you have it up against somebody cost, if you buy a policy for $300 or $400, then all those exclusions will be in it. If you're spending $1,000 or more, then these exclusions won't apply. So make it as simple as this. If you keep track of this one slide here, and one slide is telling you that the less exclusion you have in the policy, the broader your contract. If any of these ones are on your policy, you have a problem. Simple as that. They're not on there, guess what? Great. You don't not be an insured versus insured exclusion in your policy. There shouldn't be a breach of contract exclusion in your policy, a discrimination, noise, none of those things should be in your policy.
Right, exactly. Yeah. Policies that are designed, that are customized for community associations have insured versus insured coverage and entity versus insured coverage as well. And they basically won't exclude all these things that we talked about, mentioned to be concerned about. Okay, great. And now Pamela, she'd like to know, property management coverage. Do you defend property management company on basis or excess basis? Primary basis or excess basis? Most management companies have their own E&O coverage.
Yes, okay. Most of them have their own E&O coverage, but what happens is this. If the property manager is acting at the direction of the board, meaning this, if I tell the management company to tow away Sherry's car, because Sherry's been parking in visitors parking for the past 3 nights and she shouldn't be parking there. So now all of a sudden, Sherry's car gets towed away and Sherry gets upset with me or the property manager. She may see the property manager towing her car away and just sue that individual. Now, what happened is that property manager saying, I was acting on behalf of the board of directors. I have an agreement in the contract. They will reimburse me for any of these type of expenses. That's why we add the D&O. That's why we add the property manager to the D&O policy. By contract, the board has to identify them. And so what we do is we make sure that that board and a management company is added as long as they're acting at the direction of the board.
Direction of the board.
The difference between a property manager making a mistake with the budget or towing the wrong car away. Let's say the property manager towed the wrong car away, So he does things that he's responsible for his own errors and omissions versus acting in the direction of the board.
Now you wouldn't tow my car, would you, Kevin? You wouldn't do that.
No, of course not. No. As long as you move it out of that visitor's parking place by tomorrow morning, you have nothing to worry about.
As long as I'm legally parked.
Exactly.
Great. And now the questions are coming in fast and furious here. Thanks, everybody. We can keep going as long as you can.
Sure, let's keep going.
Let's keep going. Okay, Michael M. Thank you, Michael, for your question. Can you give us more examples of the non-monetary awards that can occur with homeowners associations and condo associations? Yes, there's tons of them we could talk about. There's a lot.
I can tell you, most of the claims you're going to see in a homeowner association, in a condo association, is not about money. They don't want money. They want to have the right to do what they want to do because they bought their home. And who are you to tell me, Sherry Branson, that I can't put a fence up, that I can't put a new deck up, that I can't tear down the building, the unit next to me and combine the two, that I can't put, your imagination can't, pets, okay? This is your favorite one. Tell a pet story there, Sherry. You love the pet stories.
Oh yeah, I mean, there's all kinds of pet stories, but basically, a breed of dog, like you can't have a certain breed of dog. I know some people
they're too fat. They're fat.
Yeah, potbelly pigs. Some people, decide to have a pet like a potbelly pig, and doesn't fall under the CC&Rs. It's not one of the approved pets, that kind of a thing. But then people can say it's a comfort pet. Then you go into that area where they'll say, well, I need this. I have a doctor's note saying I have to have the potbelly pig, or or this particular dog, you know, so it can get complicated. It can get really
And,
complicated. And people
and
love
the bottom line is that they're not asking for any damages. There's no damage. They're not asking for any money at all. They want the judge to say that I'm the president of the board and I'm incompetent. I have no authority. I have no idea what I'm doing. Will you please tell Kevin it's okay for me to have my pet or my parking space or my 8-foot long fence or my deck or whatever it is.
Yeah,
And
my
that,
purple house, paint my house purple or something.
most of the claims you're going to see in a homeowner association has nothing to do with money damages.
They're very emotional claims. They're very personal claims. Great. And Wayne Bernstein would like to know, thank you, Wayne, for your question. If there's no EPL and an EPL type claim is filed, would they not need EPL coverage, especially for a volunteer?
Okay, let's see. All right. Say it again. Let's see if we can make some sense of it.
Let me see now. If there is no EPL, so if they've no EPL, and EPL type claim is filed, would they not need the EPL coverage? I guess he's saying if it's for a volunteer. If it's for a volunteer.
All right. Okay, let's do it this way. Let's break down the EPLI coverage. Okay, if you live in a community association, most of them don't have employees. Okay, so EPLI won't apply at all. Okay,
Right.
So EPLI only applies if the association has employees. If they have employees, then they should have an employment practices part. Either they have it, it's included in their D&O, or they need a separate EPLI policy.
Right.
If they don't have employees, then it's not an issue.
They shouldn't worry about it. Yeah, they shouldn't worry.
If they have volunteers already covered in the definition of insured. In definition of insured, we're covering volunteers, committee members, board of directors, past board members, current board members. So you're covered in the volunteer section.
Okay, great. That was a great question. Thank you. And now we have another question from Terry. Terry P would like to know. She says, even though a claim may be excluded if there is bodily injury, will the D&O policy still defend the complaint?
Okay. All right, Terry. Hope you're to South Carolina, Terry? That's the kind of question you would ask.
Thanks, Terry.
All right, this is it. This is important. If there's a claim arising out of or attributable to bodily injury, there's no defense costs. Okay. Once they say if it's but for bodily injuries arising out of bodily injury at all, there is no defense costs.
Okay.
All right.
Thank you.
That's a tough one.
Do we have time for one more?
Sure, let's do one more.
Okay, this is our last one, everybody. This is from Catherine P. She asks, what about not opening the amenities because we cannot meet the government requirements to reopen? So I guess she's saying if we don't reopen the amenities because they can't meet the requirements to reopen them, the government says you have to do X, Y, and Z, maybe they're saying social distancing, etc., and they can't do that. So they choose not to reopen.
Okay. Choosing not to be open is the best thing the board can do in terms of choosing to reopen. If they choose to reopen, the likelihood of them having a D&O claim that's not covered is greater. Okay, what I mean by that? If you open up and a sickness happens, if somebody comes to the pool and all of a sudden they know that they had COVID, somebody there has COVID, or somebody in the building has COVID, you open that pool up and everybody's sick, you open yourself up to some incredible exposure. So I would say this, is that making a decision not to open is a better decision to do, because if you're sued because they're not opening, it's better opportunity to be defended versus if you open it and somebody gets sick. So long as you stay closed and you're being sued because you're doing your job and you know what you should be doing. And again, it's the same thing as saying my pool hours are from 10 o'clock in the morning to 10 o'clock at night. That's my pool hours. Now, people don't like it. They'll fight it. But you made your decision. It's your job. It's your fiduciary responsibility to make this kind of decision. People don't like it. People want to go swimming at 2 o'clock in the morning. People want to go to the jacuzzi at 2 o'clock in the morning. But if you follow your rules, if you're sued for it, again, the rules are being challenged, not somebody getting sick is being challenged.
Absolutely. Yeah. Great.
I think the bottom line is this. In terms of COVID thing, is that if you keep things shut down, you have better chance of getting coverage than opening up.
Absolutely. Okay. It's safer. Okay, great. Fantastic. Thank you, Kevin. And thank you for all your great questions, everybody. That was a lot of questions. That was a very busy Q&A section. And I did want to mention one more time that we put recordings of all of the webinars, today's webinar and all of our past webinars on our website, which is kdisonline.com. So feel free to visit our website anytime. I have marketing flyers there about all of our products, and I have claims examples, etc. So feel free to visit that. We also have product videos. And if you'd like to have the link to those, you can always copy that link and save it, and you could share it with other people as well. So thank you, Kevin. Thank you for a great webinar.
Thanks a lot.
Thank you, everybody, for joining us, and have a great afternoon, and stay safe and wear your mask.
That's it. Thanks a lot. Take care.
Thank you. Thanks, everybody. Take care.